Welcome, everyone. My name is Michelle Buman. I'm the program specialist at the Iowa City Senior Center. And welcome to our second week of our 4-week session on our gun violence epidemic. So alternative approaches. Today, we are talking about the Second Amendment, and our guest speaker today is Tom Petties. He has been a professor at the University of Iowa in the law school for over 20 years, or about 20 years. Before coming to the college, he served as a law clerk in the United States Court of Appeals for the Fourth Circuit. He was in private practice, and then he's been here in our area since then. You may recognize his name as he appears from time to time on Iowa Public Radio's River to River program, discussing Supreme Court cases and other legal developments. So we're really very grateful to have you today and your time. Again, I want to thank Liz for putting this together and working to make this series happen. This has been in the works for a few months now, and we're really proud to sponsor it through the Senior Center. And Liz would like to make an announcement before we get to the presentation. So I'll go ahead and turn it over to you, Liz.
Okay, thank you. I'm wearing my Wear Orange uniform because coming up this weekend, we will be honoring National Gun Violence Awareness Day, and there will be an event at Weatherby Park this Saturday, June 4th at 2 p.m. With speakers, kids activities. There will be a peace walk from the park, just affirming our commitment to a future free of gun violence. And the public is most welcome. I know you all have an interest in the topic of gun violence, maybe a pressing interest in light of the last couple of weeks. And so we want to extend a special invitation to everybody. And Michelle mentioned my involvement in putting the course together. I need to acknowledge my two colleagues, Lenore Holte, and she's shaking her head, but sorry, Lenore, and also Tricia Zabrowski, who've been just invaluable in putting this course together. So I think it's time for Todd to share his wisdom with us.
Well, that's optimistically put, Liz. Let me say at the outset, I'm not here to sell you anything. I'm not here to sell you a particular view of the Second Amendment. I'm not here to argue that it means one thing rather than another. I'm going to be very highly descriptive. I want to tell you about its history, its text, its history, some of the underlying concepts, and then what the Supreme Court has told us about it. And then I'll conclude by briefly telling you about a case that's a big case that is pending at the United States Supreme Court now, and we will get a ruling presumably here in the next week or two or three. I'll tell you about that, and then we have a proposed amendment to the Iowa Constitution on the ballot in November, and I'll close with that. And if my presentation is at all successful, when you look at the text of that proposed amendment, you'll have an even better understanding of its significance than you might now if you haven't studied this before. So I've got some slides. I'll tell you, I have the chat window open, but because I'm sharing my screen and kind of trying to pay attention to what's going on, I'm not going to look at the chat. And so if there's things in it that are timely, I'm going to miss them. So Michelle, you feel free to interrupt me or something if you think there's something I should attend to or someone's having a technical problem, okay? Okay, so the text of the Second Amendment, as you can see there in the little graphic on the right, makes reference to a well-regulated militia. And so just to give you a little more detail about where I'm headed, I'm going to start with that. I'm going to start with the militia, what it was, what the concept was, and at least one reason why it's presumably referenced here in the Second Amendment. I won't stay in the weeds of history for too long, but that's where I'm going to start, and then we'll work our way to what the Supreme Court says about it today. Okay, so but we'll start with the militias. It was, as you might recall, reading Once Upon a Time, a little skirmish between colonial militias and British forces that started the Revolutionary War. Each of the colonies, each of the British colonies had their own militias, and what they were, very loosely organized group of men, late teenagers up to say middle-aged men. If you were male and you were healthy, you were generally expected to have a weapon at home, so that if the call went out at some point, that not necessarily that the British were coming, but who knows what the local threat might be. If the call goes out, you've got a weapon to grab, you head out your door and you find the other guys who are running out of their houses with their weapons, and you take on whatever the task is that led to your being called out. So very, very loosely organized. You don't sign up and join, you don't opt in, you don't apply or something. You're a guy, you're healthy, you're old enough, have some kind of weapon around in case we ever need you. Okay. So it starts that way. And in the Revolutionary War, they're going to play a role, even though we have an organized military. Our very first attempt at something resembling a constitution was, of course, the Articles of Confederation that drafted during the Revolutionary War, and it's the system of government that we lived under for a time. It was a failure for many reasons that aren't relevant here. There was no president, there wasn't a judiciary. Congress, the little Congress that existed, had very few powers, it had very little access to funding and so forth. But the reason that I reference it is because it had a provision that referred to a well-regulated militia. And there's a decent amount of text on a few of these slides, though I've tried to avoid that. You don't need to work your way through this and master this or anything. I just want you to see that the texts are real and make it a little bit concrete. But what this paragraph does that was in the Articles of Confederation, I've got the dates there, prior to the Philadelphia Convention's Constitution draft being ratified. And what it said was to the states, and kind of the unitalicized part that takes up 3/4 or so of what's on the page here, it said that states were not allowed to keep a military forces in any kind of an organized way, except with Congress's permission. Okay, so this newly created kind of alliance of newly formed states, you had to get Congress's permission to have organized troops. But it said at the end, every state had to keep up a well-regulated militia. So there's a distinction drawn even there in the text between kind of the official military and then this unofficial gathering of all the men in the locale. All right. Now, the Articles of Confederation fail for lots of reasons, really having nothing to do with the militia, and they need a new constitutional system. So they're in Philadelphia, they're debating what that system should be. And of course, they debate all kinds of things having to do with what the Constitution should say. With respect to militias and armies, the big debate was, should we rely just on militias? Should we allow the states to form their own troops? The Articles of Confederation said they had to get Congress permission. Should we lift that and tell the states that they can keep their own troops? Should we have a national army? And this was a tough issue for them to solve. There are a lot of pros and cons, because on the one hand, the Revolutionary War experience had taught this young country that they need a centralized army. We started with the militias, but it was clear that these very loosely organized militias did not have what it took to single-handedly take on the British forces in the Revolutionary War. And so we needed an army, we needed a General George Washington to lead that army and so forth. The militia continued to play a role, and they emerged from the war as heroes. But that experience taught us that there's something good about having one official military force that transcends state borders. On the other hand, there was tremendous anxiety about what this new national government was going to do. And that's one of the big story themes about the origins of the American Constitution, is trying to give the federal government enough power to do what we need it to do, while not at the same time giving it so much power that it can basically become the new oppressor and replace King George III as this distant, for many states, it would be a distant set of rulers who might be oppressive in some way. And so giving this newly created federal government an army, a powerful army, that was a threat. People said, maybe we're sold on the idea of creating a new national government and giving them more power than the Articles of Confederation gave, but it's still a frightening thing. So do we really want to give them an army? On the other hand, we kind of need an army. And so what they did is in Philadelphia is they came up with a compromise. And what they said with respect to armies is, yes, Congress can raise an army, but when they ask for money for the army, they got to ask every 2 years. Okay, so they use the power of the purse a little bit to have to keep coming back for approval to fund this thing. And the states are told that unless Congress agrees, no state can keep troops during times of peace, very much like what the provision was under the Articles of Confederation. Now, you might ask, what about the state militias? What are we going to do with those? And the Philadelphia delegates, again, lots of text. I don't think any of the details here matter. I just want you to see outside the Second Amendment that in the text of the Constitution, there's provisions about the militia. They refer to the militia as this thing that already exists. Congress shall have power to provide for calling forth the militia. And the militia, of course, does exist because, again, it was understood to be this unofficial thing. If you're born male, and you make it to your late teenage years and beyond, you're in the militia. Congratulations, you're supposed to have a weapon at home. And so Congress is told, you can call those guys out, you can write some rules for them. And it's really this hybrid entity. Congress has some power. If you read down or just kind of skim down, you'll see that the states will train the militia, but Congress can describe the discipline by which they're going to be trained, trying to kind of straddle two worlds where the states have some power over the militia, Congress has some power over the militia. The president is told that the president can be the commander in chief, not only of the Army and Navy, but also of the militia when they're called out. Okay. That's all today, the National Guard. So we've got the Iowa National Guard. So the National Guard today is and it was renamed and kind of rethought of about a little over a century ago and denominated this way as the National Guard. But those are the origins of the National Guard, which continue to be kind of this hybrid state federal entity where a governor can call out the Guard, the president can call out the Guard, and so forth. Okay. Now, that's what the delegates to the Constitutional Convention proposed, right? The militia will continue, here's who will control it, and so forth. And Congress will have the power to create an army if it wishes. So now the document is sent out for ratification. And I give this to you because I want you to see that phrase, well-regulated militia, show up again in another text that precedes the Second Amendment. We saw it in the Articles of Confederation, where the states were told they had to maintain a well-regulated militia. Well, when the Philadelphia delegates, the summer of 1787 ends and they send this Constitution out for ratification, we got to sell the country on it now because it's state by state. We're going to go around and see if this thing can get ratified. And so the Federalist Papers, as many of you know, maybe all of you know, a very famous set of essays that were written by prominent people, including Alexander Hamilton, John Jay, and James Madison being the other two, basically making the pitch for the Constitution. And so they go provision by provision and overarching concept by overarching concept, trying to tell people what the Constitution does and does not do. And with respect to the Army and the militia, what Alexander Hamilton said was, we're still going to have the militia. That's a good thing. And maybe the militia will be so great that Congress will decide we don't even need an army. It's not going to turn out to be the case. One of the first things Congress does when it is formed is decide that it's going to create an army. But we're not yet to that point on the timeline. And so Alexander Hamilton says, if we have a great militia, we may not need an army. And if Congress does create an army, it'll be great to have the militia there because they'll be kind of a counterforce, a check. A lot of you are worried that this newly created national government is going to abuse your rights and become the new King George III and will use its army in bad ways. Well, the militia will still be there and they will help the states fight back. Okay. And so he talks about a well-regulated militia being desirable for those reasons. Now, when people are reading the Federalist Papers, they're reading the Philadelphia draft, there's a lot of, as I've already indicated, a lot of broad-ranging anxiety about what Congress might choose to do. with respect to the militia, the fear was, what if this newly created federal Congress decides to disarm the militia and come around, send federal officials around, knocking on doors and telling these guys, you got to hand in your gun. It's now illegal to have a gun. What if Congress does that? And of course, they were worried about all kinds of things. What if Congress decides that it wants to establish a religion? What if Congress decides that it wants to create some crimes where there's no jury trial? What if Congress creates systems of punishment that are cruel and unusual? What if this newly created Congress decides to make it illegal for you to publish newspapers, to speak? And so out of that, we get a promise. And the promise is going to culminate in the Bill of Rights. But during this kind of ratification debate era, when people are reading, some people are reading the Federalist Papers, other people are reading other things, debating, should we vote yes on ratification or not? The deal that was struck was the proponents of the Constitution said, vote yes on ratification. And right away, when this newly created Congress comes into form, they will they will put together a set of provisions that will protect your individual rights in a variety of ways. It will list things that Congress and the federal government more broadly cannot do to you. And sure enough, so there are enough people in the country say, okay, I'll vote yes on ratification, but I want to amend it right away and add some things. And that turns out to be the Bill of Rights, which are very quickly ratified just a couple years after the Constitution comes into force. The First Amendment about freedom of speech and establishment of religion, the Eighth Amendment, cruel and unusual punishment, and so forth. And for our purposes today, the Second Amendment. Okay, and so the Second Amendment text says, a well-regulated militia being necessary to the security of a free state. So let's just look at that clause there just for a second. Understanding this history about the Articles of Confederation requiring the states to maintain a well-regulated militia, the role that the militia had played helpfully in the Revolutionary War, the Constitution talking about it being this hybrid state federal entity, Alexander Hamilton arguing, using that very phrase, a well-regulated militia is going to help protect the people's rights, so that if this new Congress comes along and the new federal government comes along and is oppressive and uses its army in evil, oppressive ways, the militia will be there to help fight back. With all that history in mind, we look at the Second Amendment. Again, it says a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. So there's our text, okay? There's where it comes from. Now we say, now what does it mean? What exactly is this right to keep and bear arms? What is its scope? What's its relationship to the militia clause that opens the text of the Second Amendment? It's a surprisingly long time before we get any input from the United States Supreme Court on those questions. And until 2008, in a case called Heller, which I'll be focusing on here in just a second, really the only guidance we had from the United States Supreme Court came in this decision, this ruling called Miller from the 1930s. And it's a very kind of ambiguously written opinion, which is why I have this famous optical thing on the left where you either see a very young woman wearing a fur coat or you see a very elderly woman with a prominent chin and nose. You can kind of look at that image in two ways. People could look at this, at the Miller decision, in two ways and could read the Second Amendment in two alternative ways. And I'm going to read to you the quote that's here. The case had to do with some guys who were charged with shipping or carrying short-barreled shotguns across state lines without paying a tax, a federal tax that was required if you were going to do that. Congress had passed a law saying if you're going to pass short-barreled shotguns across state lines, you got to tell the federal government you're going to do it. You have to pay some money and so forth. And these guys didn't pay the money. They're arrested for taking their short-barreled shotguns across state lines, and they argue that they have a Second Amendment right to have those weapons if they want to, okay? And the United States Supreme Court rules against them, upholds the law, upholds this law banning the transport of short-barreled shotguns across state lines. But the question is why? Why does the United States Supreme Court rule that way? And at the heart of the ruling is this little passage I have here. In the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches length at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia. So unless short-barreled shotguns have something to do with an effective militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. Now, there's two ways to read that passage, at least two ways, maybe there's more than two, but there's two leading ways at the time. One way is to say that what the Second Amendment is all about is just protecting the militia as a militia, wanting to make sure that Congress does not come in and disarm the militia, thereby taking out all the resistance that the National Army might face if an evil president or somebody is going to send that army out to oppress the people. Okay, so and on that reading, we would say, well, these two guys who were arrested here, were they members of a militia? Were they in the National Guard? Did they own these weapons pursuant to their membership in the National Guard or something? Unless you're claiming the right to possess a weapon because you're a militia member, then the Second Amendment has nothing to do with you. That's one way to read this. Another way to read this is to say, no, you don't have to be in the militia in order to have the right to have a weapon. You don't have to be male, for example. You can be female, no military service of any kind, just a store owner who wants a gun or to protect yourself at the store or at home. And on this reading, one would say, what the court is really saying here is not anything aimed at limiting the scope of the Second Amendment with respect to why you're allowed to have a gun or who can have a gun, but rather what kind of gun the Second Amendment protects. And on that reading, this passage is just about saying, well, unless a short-barreled shotgun is the kind of weapon that a guy would have if he's serving in the militia, then it's not covered by the Second Amendment. See, there's lots of questions here. We want to know who can have a gun, when can they have a gun, where can they have a gun, what kind of gun they should have. And on this second reading, Miller was just about the kind of gun. Wasn't at all about when you can have a gun. And on that reading, then you don't have to be a member of the militia. That was all we had to work with from the United States Supreme Court until 2008. And this is by far the most important Second Amendment ruling that we have to date. Again, today's June 1st. Later this month, we may get one that eclipses Heller. But for right now, understanding what the Supreme Court says about the Second Amendment, it's all about Heller. So this is Dick Heller. Dick Heller, pictured here in front of the United States Supreme Court. He was a well-chosen plaintiff. If you're going to do civil rights litigation where you're sending in a plaintiff to claim a certain right, you want to pick your plaintiffs carefully, and he was very carefully chosen. His job was protecting federal judges. He worked at the Federal Judicial Center. He carried a gun as part of his job. There were judges who worked in the building, and his job was to protect them. Okay, Dick Heller, when he went home, wanted to have a handgun in his home for self-defense. The District of Columbia had adopted a series of regulations having to do with licensing and trigger locks and so forth. But basically, when you add all those regulations together, it was illegal to have a handgun in your home. And he said, I think the Second Amendment gives me a right to have a handgun in my home. And so he files his lawsuit. Okay. The court decides, and Justice Scalia writes the majority opinion. It's a 5-4 ruling. Okay, let me back up here. Remember, we were talking about this. 4 justices, the dissent, takes what I described as the first reading, saying basically, unless you're in the militia, claiming a right to possess a weapon pursuant to your obligations as a member of a militia, unless that's you, the Second Amendment doesn't give you anything. That's the view of 4 justices. 4 is a minority of 9. There's 5 justices who took the latter view, as we'll see here in a second as I talk through this. So here's what the court says in Heller. They take the language of the Second Amendment and they say, okay, let's break it down into its 2 parts. They say we've got the first part, which has to do with the militia. That's what we'll call the prefatory clause. And then we have kind of the right protecting provision or portion of the text. We'll call that the operative clause. It's the clause that's doing the real work. And so the prefatory clause states a reason for why we're going to do what we're going to do. and then the operative clause describes what we're actually doing. Okay, and so the court says, now which of these should we start with? And the dissent said, let's start at the beginning. Let's start with the militia. It's all about a militia, and that's why we take the view in the dissent that unless you're part of a militia, you don't have a right to possess a weapon. And Justice Scalia's majority says, no, that's not how it works, because when we look at prefatory clauses in statutes and state constitutions and in English law, when there is a prefatory clause, those prefatory clauses don't limit the scope of the operative clauses. What we should do, the Justice Scalia's majority says, is let's start with the operative clause. Let's interpret that. And then to see whether we've kind of reached a good, reasonable, accurate conclusion, let's see how it fits with the prefatory clause and see whether it fits together. And so they start with the operative clause. And what they say the operative clause means, the right of the people. First thing they say about that, the right of the people is not some collective right, it's an individual right. In other places in the Constitution and in other constitutional texts and state constitutions, if we talk about a right of a people, that's a right that individuals hold as individuals. The right of the people to keep and bear arms shall not be infringed. Well, what does keep and bear mean? Well, to keep means to have, the court says, and to bear means to carry, especially for confrontation. So self-defense, the work of a militia, hunting, there's all kinds of confrontations one might imagine. And so that's what that language means. Okay, so what the operative clause tells you is that you, as an individual, have a right to have and carry with you a weapon in case of confrontation. Then the Supreme Court says, okay, how do we do? Let's go back and look at the fit with the prefatory clause and see whether this makes sense. And Justice Scalia's majority says it's a perfect fit. How so? Because in the days of the militia, guys were expected to have a weapon at home, to have a weapon, to keep a weapon, and that they could carry with them as they head out the door in order to defend the locale. And that concept of the militia goes back, centuries into English history in one form or another, and also worries about the centralized government disarming the militia as a prelude to oppressing them. And so you go back to the English Bill of Rights in 1689. In the English Bill of Rights, there's a promise, particularly to the Protestants, we're not going to disarm you, because the crown, the Catholic crown, had tried to disarm the Protestants in order to make them more subservient and easier to oppress. King George III had tried to disarm the colonists in order to enable the British Army to roll over them more easily. And so Justice Scalia's majority says, or let me just say the court says in Heller, the idea of the Second Amendment was give everybody a right, I'll come back to the everybody, but give most people a right to carry a weapon. Why are we doing that? Well, one reason is because we want to make sure that Congress can't come along and pass a law making it illegal to have these guns, lest the militia be stripped of its weaponry. That's just one purpose, the court says. There are other purposes too, like hunting, like ordinary home self-defense. Okay, just one purpose, but it is a purpose. Now, they go on and say some other things that are important. One thing they say is so coming back to this question from Miller, what kind of weapon, a short-barreled shotgun, does that count? Is that protected by the Second Amendment? The court says in Heller that the kinds of weapons that are protected are those typically possessed by law-abiding people or law-abiding citizens for lawful purposes. Okay, and so the court says, for example, that's why Miller was decided the way that it was in 1939. Law-abiding citizens did not typically possess short-barreled shotguns for lawful purposes. The guys walking around, the people walking around with short-barreled shotguns were people who were up to no good. And so that's why Miller said those guys lost. The Second Amendment didn't protect their right to carry those short-barreled shotguns across state lines. Now, one really important thing to recognize about that is note the control that gives ordinary Americans in deciding what kinds of weapons are going to be protected and which are not. It comes down to, well, what are they buying? And so AR-15 rifles, like in the recent Texas massacre, for example, there's about 20 million of them in the United States. That's a pretty astonishing number, about 20 million of them. So if you ask, are AR-15s, are those protected by the Second Amendment? If you're going to go with the test that Heller, now maybe the wrong test, maybe the Supreme Court should adopt a different test. Again, I'm not here to sell anything. I'm just describing to you, what the Supreme Court has said and what its application is going to be. If you're going to ask, are AR-15 rifles, are they protected by the Second Amendment, or is a person's right to possess and carry an AR-15 protected by the Second Amendment? We would say, well, is it the kind of weapon that a typical law-abiding citizen might possess for lawful purposes? Well, if there's 20 million of them, 20 million of those weapons in the country, overwhelmingly possessed by law-abiding people, the Heller test is probably going to say that those are protected. They say some other things in Heller about the Second Amendment and what it does and doesn't cover. They provide some assurances to those who think that absolute calamity is going to ensue. They say, this doesn't mean that every law regulating weapons is unconstitutional. Many laws, for example, banning concealed weapons, those will be fine. Laws banning possession by felons or people with mental illnesses, those may be fine. Banning guns in what the court described as sensitive places like courthouses, government buildings, schoolrooms, and so forth, those are fine. Any kinds of conditions like background checks on the commercial sale of arms, those are probably fine. Okay, so they list some things that the Second Amendment probably protects. None of those things were at issue in Dick Heller's case. Dick Heller was not arguing for the right to carry a concealed weapon. He wasn't a convicted felon. He was not saying that he should have a right to carry his gun into his daughter's school or something like that. Dick Heller's case was all about having a handgun in the home for self-defense. Okay, so this is just what we would call dicta. It's not necessary to the resolution of Dick Heller's case, but the court is just kind of telling us what it sees out there on the periphery, but it doesn't tell us why. Okay, it doesn't say why is it that the Second Amendment will permit those things. There's a couple possibilities. One possibility might be that the things on that list, concealed weapons, felons convicted felons, they're done serving their time, but they still have felonies on their record, or mentally ill wanting to have guns. It could be that those are just totally outside the scope of the Second Amendment. So if you're a convicted felon, you just flat out have no Second Amendment right. If it's a concealed weapon, it's just flat out not covered by the Second Amendment. You say you want to carry a gun into City High School. Well, the Second Amendment doesn't apply in City High School. That's one thing that the court might have in mind. The other thing that the court might have in mind is that there's a test that applies. The Second Amendment does apply in all those settings, but the test that we're going to apply, the test that the Second Amendment requires, will be met. Okay? Now, if that's, and stick with me here, we're getting kind of toward the end. I know, spent a few minutes here with some legal concepts, but we're going to get payoff here in a couple different ways. So I think it'll be worth the effort. What kind of test might it be? Well, there's three main tests they're pervasively used in American constitutional law. They're not always used, sometimes it's different tests, but these three tests are are familiar to any attorney, to any law trained person. And as you go, I've got the three of them are listed here. And as you work your way from the top of the list to the bottom of the list, the test becomes more stringent. The test becomes harder for the government to satisfy. So the rational basis review is very easy for the government to satisfy. If just in constitutional law in general, if you look at a setting where you say, okay, rational basis review is the test that the court's going to ask, I can tell you already that there's a very, very high likelihood, high 90%, the government's going to win. Whatever the case is, whatever the facts are, whatever the constitutional provision we're talking about, if a rational basis review applies, the government's going to win. You get down to strict scrutiny, that largely flips. You say, well, if strict scrutiny applies, government's probably going to lose. The individual's probably going to win. So let's think about how this would apply here for a second, and then I'll tell you what we know, and I'll tell you what we don't know about what's going on here. We might say, let's take this, the law banning concealed weapons. It could be that when we talk about concealed weapons, just rational basis review applies. What that means is the government just has to have some rational reason for imposing the restriction. Okay, that's a very, very low bar. Just some rational explanation. Well, concealed weapons, you know, people can be frightened by them. People who you don't know that someone's armed because it's concealed, so you have an encounter with them that escalates. You never would have had that encounter had you known that they were armed. So if someone's going to be carrying a weapon, it really needs to be an exposed weapon, so everyone around them knows this person's carrying a gun. That sounds rational. Okay, convicted felons. Well, people have already violated the law in a serious way before. And so even if they've served their time, maybe those aren't the kinds of people we ought to have walking around with guns. If rational basis review applies, we'll say, yeah, that'd be fine. Okay. Well, what does the Supreme Court tell us? And I'll get down to intermediate and strict here in just a second. The Supreme Court says it's not that one. Okay. Whatever the test is that the Second Amendment requires, whatever the test is, it's not that. It's going to be more demanding than that, but we don't have to pick between intermediate scrutiny, strict scrutiny. We're not even going to elaborate on that little list I've got shrunken now in the top left about sensitive places, felons. We're not going to talk about that, how the analysis would work. Just all we have to tell you right now today to decide Dick Heller's case is rational basis review does not apply, and we don't think that the District of Columbia restrictions on handguns in the home for self-defense would satisfy either of these two tests. And if those DC laws will not satisfy either of these other two tests, then we don't have to decide today which of them applies. We just say, well, it's not either one. You know, bring us a case that's a tougher case that maybe will force us to choose between intermediate scrutiny and strict. Okay. So they tell us it's not rational basis review, but they don't tell us which of these other two it will be. Now, there's reason to think that it's not strict scrutiny. I have noted here parenthetically, the NRA very strongly favors strict scrutiny because it gives gun rights, gun possession rights, this by far the strongest protection. But there's reason to think that that's not what the Heller court would have said had they been pressed to decide. Let's look at this ban on felons. Just think about it for a second. And I can tell you a little bit more about strict scrutiny in the meantime. We're in the process. So the court said, again, without explanation, a law banning gun possession by convicted felons, that'll be okay. That probably would not pass strict scrutiny, because what strict scrutiny says is you have to have a very compelling justification, and saving people from getting shot, that's definitely going to be a compelling justification. But the law has to be, quote, narrowly tailored to that goal. Means it has to be a very good fit. Big overgeneralizations about people, those aren't tolerated by strict scrutiny. And when we talk about convicted felons, there's all kinds of crimes that are felonies. A lot of them are not violent. And so if you have a law, as we do both at the federal and state level today, saying if you're a convicted felon, you can't have a gun. If we're going to say that, just I don't care what felony you committed. I don't care whether it was a violent felony. I don't care how many years ago it was. I don't care about the circumstances in which you committed the felony. I don't care about any of that. You just committed a felony. A felony, by the way, is a crime punishable by a year or more in prison. That's the difference between a misdemeanor and a felony typically. What's the worst punishment you could get? If it's a year or more in prison, then it's a felony. If it's less, it's a misdemeanor. So if all I know is you committed a felony and I'm going to say you can't have a gun anymore, that's not a narrowly tailored law, because there's a lot of convicted felons who we have no reason to believe pose any kind of a threat, but yet the law is applying to them. Okay, the Supreme Court, though, says we don't have to choose. What are lower courts doing? Here's what lower courts are doing. Lower courts are saying, trial level federal courts and the intermediate courts of appeals that sit just below the United States Supreme Court across the country. Lower courts have kind of all coalesced around the following view, that if what we're talking about is a case like Dick Heller's, where we're talking about ordinary weapons, especially handguns, in the home for self-defense, and someone's challenging a law that makes that hard to do. Someone wants to have a handgun or maybe a rifle in their home for self-defense, and there's some law that is making that really difficult. Then courts will say, well, we're going to apply strict scrutiny. And the law has got to be very narrowly tailored to serve some kind of compelling goal. If it's any other kind of a law, we're going to apply intermediate scrutiny. It's not as demanding. It's tougher than rational basis review, but not as demanding as strict. And so if we're going to pass a law, for example, talking about magazines, how many bullets can be loaded into a gun at one time, and we're going to say, well, no more than 10, or no more than 5. That's not making it difficult to have a gun in the home for self-defense, so we'll apply intermediate scrutiny. And the version of intermediate scrutiny that the lower courts are applying, the government is winning about 90% of the time, meaning it's not a very difficult test. So you think if this is a spectrum or rational basis review, the government's always going to win. Strict scrutiny, the government's usually going to lose. Where does intermediate scrutiny fall? It doesn't fall in the middle. It's pushed on that spectrum pretty close to rational basis review, where the government is almost definitely going to win. The empirical people, some scholars who've gone out and done the research, the empirical research on all these rulings, 90% or more time the government wins. Okay, the NRA is not happy about that, and that's going to, and a lot of other folks who are strong proponents of gun rights are not happy about that, and we'll get to that in here in just a couple of minutes when I get to my last slide and the proposed amendment to the Iowa Constitution. Okay, so Heller was in 2008. In 2010, the Supreme Court handed down a decision called McDonald, and the main significance of that ruling was, in that case, the court held that the Second Amendment places restrictions not just on the federal government, but also on state and local governments. And so the city of Chicago had a very tough set of handgun laws, and the court said that those laws all had to pass the Second Amendment. I can come back to that and explain that more carefully if it interests you. What I want to pull from here is Justice Breyer's dissent, because in that case, he pointed out, and he's right about this, all the kinds of questions that the court has not yet answered. And there are a lot, okay? What about outside the home? I'll come back to that here in a second, okay? Do you have a right? Because again, Dick Heller wanted to have a handgun in his home for self-defense, and the Supreme Court said he has that right. What about when Dick Heller steps out into his front yard? What about when he leaves his property? What about when he's in a car? What about when he goes to the grocery store? Does it extend out there? Okay. What kinds of guns are necessary for self-defense? We talk about weapons typically possessed by law-abiding citizens. Is it in fact going to include things like AR-15s? If so, what is it about an AR-15 that pushes it outside the Second Amendment? What if there's a child in the house? What if there's a convicted felon who lives in the house as a roommate? I want to have a gun. My roommate is a convicted felon down the hall. Does that affect my ability to have a gun? Prior drug offenders, et cetera. So there's all kinds of questions that have not yet been answered that Justice Breyer flagged. And one of those questions is the one that is pending in front of the United States Supreme Court right now. And it goes to the thing I've circled here. What about outside the home? If it does extend outside the home, when, where, and how much protection does the right get? Because the case that was, as I have indicated here, it was argued in November of last year. So the opinion is due anytime now. I think, I could be wrong about this, but I think all of the other cases that were argued in October, the Supreme Court's year starts the first Monday of October. I think all of the cases argued in October have now been decided, if I'm not mistaken, and a lot of cases argued after November have also been decided. And so this case, I assume we're getting it very soon. And some people speculate that the Texas shooting might have prompted the court to withhold releasing it, but that's just speculation. Here's the issue. New York law says, and has said for about a century now, so it's an old law in New York, that if you want to carry a concealed handgun outside the home for like self-defense, you have to get the government's permission. That's the first step, is just 2 or 3 steps here in the explanation. You want to carry a gun outside the home, and it's going to be concealed. You have to get the government's permission. Remember my slide, I'll go back to it if you'll just bear with me here. What lower courts are doing. Lower courts are doing, and this is what the lower court did in this case. They said, okay, is this law making it harder to possess a weapon in the home for self-defense? No, the law has to do with what happens when you leave the home. Oh, well, just intermediate scrutiny applies. It's pretty toothless. We're just going to ask the government, do you have some kind of important goal that you're trying to achieve? And are you kind of achieving it reasonably well? If so, then that's fine. And the lower court here said that, well, the reason New York is saying this is because they worry that people are going to pull those weapons out when they get into arguments with each other or road rage or what have you, and start shooting each other. We don't want those things to happen. And so we really want to say, if you're carrying your gun outside the home, you're going to have to come get our permission. What does it take to get New York officials' permission? You have to show, quote, what the New York statute calls proper cause. So you have to say to the local sheriff, chief of police or county sheriff or whoever, you have to show why you, the reason why you want to be able to do this. And it turns out New York officials are being very, very tough about handing out permission. You have to show that there's something special about you and your circumstances that make you uniquely susceptible to threat. And there's a lot of situations where people have plausible arguments for why they're unique, where the officials are saying, no, that's not good enough. So someone who has to carry a lot of cash, for example, as part of their job, New York officials have said, nope, not good enough. Someone who says, look, I live in a really dangerous neighborhood. We've had a lot of violence. And so when I walk, 6 blocks to the grocery store, I'm really at risk because this is you wouldn't believe this neighborhood is a war zone. And the New York officials have said, no, that's not good enough. Sounds like everyone in your neighborhood is dealing with the same situation. Nothing special about you. And so it's really hard to get these. And a couple guys who've been denied permission to carry guns concealed outside the home have filed this lawsuit, as well as a gun rights organization named there in the case name. So we'll see what the Supreme Court says about that. And in the course of telling us what they think, we're going to find out, presumably, whether the Second Amendment extends beyond the home. And we're going to find out whether it's intermediate scrutiny or strict scrutiny or something else. Has the potential to be an enormously influential ruling that we'll have to see. Here's my last slide. Okay, I've been talking all about federal law. Now, I described the facts of New York's case here, but I've been focusing on the Second Amendment to the United States Constitution, so federal constitutional law. Let's talk about state constitutions for just a second. Again, this is my last slide, and then hopefully I've said enough to interest you here that you'll have some questions to help fill our remaining time. Most state constitutions have got analogs to the Second Amendment in them. Iowa's doesn't, but most states do. And those state constitutions have been, those state constitutional provisions that most state constitutions have, where there's something akin to a right to keep and bear arms provision, those have been almost universally interpreted by state Supreme Courts to require something like just rational basis review, meaning, yeah, you do have this state constitutional protection, but it's not strong protection. If the government has got a plausible reason for wanting to restrict your gun possession, your gun use rights in a given situation, it can do so. So these state constitutional provisions are very prevalent across the country, but provide very, very weak protection. Here in Iowa, in our constitutional convention, our most recent constitutional convention in 1857, there was a proposal to put in something that, I don't remember what the exact text was, but something very similar to the Second Amendment. And the records that we have of the delegates debate don't tell us why it was rejected. We see it being debated. There's a committee or a delegate or somebody who proposes it, and the Constitutional Convention says, okay, yep, we'll note that, that's on our agenda. And then when they come out with a draft later, it's not there, and we don't get any explanation why. It could be oversight, it could be a conscious decision, we don't know. But for most of those states that do have these, again, it's very weak. The NRA and others, but the NRA as best I can tell, has led the charge, are trying to persuade state legislatures across the country to adopt what are widely called now strict scrutiny amendments. In cases or in states that already have these state constitutional provisions in them, those state constitutions would be amended on the NRA's proposed agenda. They would be amended to say that when there is an infringement somehow on your gun rights, strict scrutiny applies, meaning the government has to have a very compelling justification. The means by which it's trying to achieve that justification have got to be very carefully tailored to fit that circumstance. And the government's probably going to lose. It's going to trip on one of those two things. Either the goal's not going to be compelling enough, or the means are not going to be narrowly tailored enough. Individuals are going to win most of the time. And a few states have adopted these strict scrutiny amendments. Missouri has adopted one, Louisiana has adopted one, and another state or two has adopted one. Here in Iowa, where we don't have anything akin to the Second Amendment in our state constitution, the legislature has passed now in 2 sessions, as the state constitution requires. They've laid the groundwork for Iowa voters to face this proposed amendment, and it will be on your ballot in several months. And what it says is the right of the people to keep and bear arms shall not be infringed. That takes the operative clause of the Second Amendment and would pop it into the Iowa Constitution. The sovereign state of Iowa affirms and recognizes this right to be a fundamental individual right. In constitutional law, that word fundamental is loaded. That is saying if a right is fundamental, it means it's going to get very strong protection. And the last sentence of the proposed amendment makes that clear. It says, any and all restrictions of this right shall be subject to strict scrutiny. So it looks at those 3, like rational basis review, intermediate scrutiny, strict scrutiny, where the government's odds of winning and losing are largely dictated by which test applies. The proposed amendment would say strict scrutiny, so that gun owners, gun users are going to presumably win most of the time, and most attempts to restrict their those rights, they're frequently going to be struck down. Okay. All right. Well, I hope there's something there that interests you. Let's find out. See what questions you have or things you want to talk about with me or with each other. You can ask questions, or we could have a little discussion group, however you want to do this.
Well, I do have a question, Todd. Let's see, can you hear me?
Mm-hmm.
Yeah, it's about this notion of originalism.
Yes.
And I don't know if you can speak to this or not, but many pro-gun safety advocates, when they talk about what the founding fathers intended, they talk about how different the world was at the time the founding fathers lived, that they didn't have AR-15 rifles and that sort of thing. Is that something that can be brought up in a court case about gun rights, or is it a kind of, I don't understand originalism and its bearing on court decisions.
Sure. Okay, that's a great question. And originalism has meant different things at different times, and so there's kind of a prevailing understanding of originalism now, which is different from the understanding in the 1980s, when it really started to rise to the fore as a method of judicial interpretation. Originalism now says, let's look at the text that we're trying to interpret and ask ourselves what those words would have been understood to mean at the time. And so it says arms, right, to keep and bear arms. What would arms have been understood to mean at the time? Okay, speech, the press, etc. Now, in some, not in tension with that, but as something that we have to deal with if we're an originalist, is technology changes. And so let's talk about the press. You have the right to speak, and there's a right of free press. Well, the founders at the time had no idea that the internet was coming. They had no idea that satellites were coming and digital communications and so forth. They knew that there were pamphlets and books and newspapers. Okay, these hard copies that you could shove into each other's hands. The telephones, no. Okay, but communication technology comes along, and then we have to decide, well, those new communication technologies, if you're using one of these new communication technologies, do you still have a right to speak? Do you still have the right to free press? And in those and similar circumstances, courts have said, and originalists have said, you can't get locked into the particular technologies. You want to understand, what was the idea of speech, communication between human beings? What was the idea of press? Being able to record your thoughts in some kind of form discoverable by others. So you have to rise to kind of a level of abstraction to describe what the concept or what the term was understood to be at the time, understanding that technology will change. And so what those things look like will evolve. And so when we come to the question of guns, in a passage I didn't flag on a slide, the Heller majority said, Justice Scalia said in his opinion, that he noted the argument, some people say that the Second Amendment only protects the kinds of guns that existed at the time of the founding, because those are the only kinds of guns that the framers knew about. So, muskets or, whatever they had, but anything else, not covered. And the Supreme Court says that's not the right answer. And I don't remember whether they point to changes in press technology and speech technology, but they could well have as an analog to try to make the point. And so what they do, again, you have to rise to a level of abstraction. If you're going to interpret what the press means, can't lock into the technologies that exist at the time. You have to have a more generalized understanding of the press. So here you have to have a more generalized understanding of the kinds of arms the founding generation understood themselves to be protecting. And the court's answer to that question is this business about what kinds of weapons are typically possessed by law-abiding people for lawful purposes. They say, the court says that's what was understood at the time because of the militia. Guys had to have access to some kind of weapon. And these are law-abiding guys who are just going to have a weapon of some kind in the home in case the bell rings and everyone needs to rush out with those weapons to take on whatever the local threat is. So that's the way in which they describe it. So that's their test. And if that's the road that we follow, one can claim to be an originalist and still say that weapons that are much more powerful, much different than existed at the time, are still protected if they meet that definition.
I've heard the argument many a time that the founding fathers only meant single shot muskets.
Yeah.
However, I think that perhaps people who make that argument overlook the fact that these were educated and informed men, and they knew that technology evolved. They probably knew that repeating rifles, for example, were already in research and development.
Sure.
A very primitive machine gun had already been invented. So I would suggest the idea that only single shot muskets are covered by the Second Amendment doesn't really hold up very well.
Yeah. And in addition to that, in addition to what you've said, in addition to what I've already said, you just think about what kind of a text a constitution is, what kind of a document it is. They chose the word arms if they contemplated a particular kind of weapon, which, as you say, they knew that the weapons that they held were not the same kinds of weapons that people were holding 100 years earlier. They're fighting against the native peoples. As they come across from Europe, they're fighting the native peoples. The native peoples, they've got different kinds of weapons. So they know there's weapons, and then there's weapons, and things can change, and so forth. And they chose this general word arms. They talk about cruel and unusual punishment in the Eighth Amendment. Well, I'm sure they had an understanding at the time of what cruel and unusual punishments were, but they didn't specify them. They instead talked about a concept. So they give us the concept of arms. They give us the concept of cruel and unusual punishment. They give us the concept of speech, because they're writing a document that they intend to be a pretty timeless document. And what the world looks like is going to change, as they well knew. Their world looked so different than it had half a century earlier. So there's I do think that the argument that the only kinds of weapons that are protected are those that mirror the technology that existed in the late 1700s. It's a very popular argument. I don't use Twitter a lot, but I read it a lot. It's a very prevalent. It's not an argument that's, I think, is going to get traction. The Supreme Court's already addressed it. You've got too many other analogical problems when you talk about freedom of the press and so forth. The nature of a constitutional text where you speak in generalizations, that's probably not the road to success. I don't think courts are going to be, and I'm speaking about courts as one's audience. Courts are not going to buy that argument. Not only has the Supreme Court, the Supreme Court already rejected that argument, but they're not going to go back on that. There's too many obstacles. And so those who are advocating for gun safety and the ability of government to restrict and so forth need to focus elsewhere, I think, such as, for example, the kinds of weapons that are typically possessed for law-abiding purposes. Maybe that's not exactly the right test.
That's why it's very difficult to own a machine gun, for example.
Exactly. Yeah, right. And so that question, 20 million AR-15s, one might look at that and think, well, okay, if we got 20 million AR-15s, we've satisfied the test, and that was too easy. We shouldn't be satisfying the Second Amendment's requirements with such ease. We need to ask a different question that will enable us to say that AR-15s are not protected. Okay. There are arguments for that conclusion. The one that the public kind of gravitates toward is, well, they didn't have AR-15s at the time. That's not going to persuade the courts today. And so there are going to be other kinds of arguments that, if you're trying to get a court's attention, I think.
Todd, this is Lenore. Thank you so much for that really clear explanation of the different levels of scrutiny that are applied in judicial review. That I never really understood that before. And so thank you so much, because I think I get it now.
Good.
So let me ask you to just sort of pretend you remember the Supreme Court. So I'm thinking about how you explained, like, when intermediate scrutiny versus strict scrutiny might be applied. And so next week, we're going to be talking about the evidence base for the effectiveness. Sorry about my barking dog.
That's okay.
The evidence base for the effectiveness of various state laws for reducing gun violence.
Okay.
And one that's kind of come to the fore as being pretty evidence-based are laws that speak to safe storage of firearms and ammunition. Yeah. And so my understanding about that would be that kind of a thing really might be more subject to intermediate scrutiny, because it doesn't really speak to the individual's ability to obtain a weapon to use in the home. So you think so?
Yeah, you said storage, things like that.
Yeah, safe storage and preventing childhood access to a gun.
Yeah, that's it. I have no idea how the Supreme Court will one day resolve that, because if they're going to continue down the path that they're on, if they're going to abandon the path that they're on and go the way of the Heller dissent, which says it's all about militia rights, then these become very easy questions. The government can do whatever it wants, and rational basis review is all we're going to demand. And so the government's going to win all the time. But if you're going to continue down the road that the court is on, these become difficult questions, because preventing child access, for example, that's certainly a very compelling goal. You say, okay, well, we're going to say that if you have a child in the home, the gun has to be locked up, or there needs to be a trigger lock on it or something. There's one of the DC laws that Dick Keller challenged was a trigger law lock. Well, the problem there is those who want to have that handgun in the home for self-defense say, look, when it's the middle of the night and there's glass breaking downstairs and I've got to grab the gun, I can't go fumbling in the dark for the key that's going to unlock the safe where the gun is and so forth. And so if it's going to serve its function, this needs to be readily accessible. Okay. And so there's already a little bit on the books in the Heller ruling that points in that direction. And so trying to reconcile this need for immediate emergency access in the home against all the kinds of dangers that immediate, easy access creates. That's
Yeah.
the challenge.
And where something like, but I'm thinking like something like an assault weapons ban that really does speak to someone having a weapon, their ability to obtain an ordinary weapon. That would seem to be more subject to strict scrutiny, I think.
Well,
Because it's the kind of weapon, but it might be the weapon they want.
well, right now, again, the prevailing test for figuring out what kinds of weapons are protected is we're going to ask this empirical question: what kinds of guns do people own?
Right.
What kinds of guns do law-abiding people own? And if it's one that's widely possessed, owned by law-abiding people, then it's going to qualify for Second Amendment protection. We then have to look and see, okay, how is the law restricting it? If the law is just flat out banning them, even if we're a rational basis review, the law would perhaps be sufficient, but the court has already told us that that's not rational basis review. It's got to be a little more demanding than that. So I think a flat out ban is not likely to be upheld. It'd have to be a ban under certain kinds of circumstances that are pretty carefully defined.
Okay, thank you.
Yeah.
Could I ask another question? Todd, I don't know if you saw the guest essay in the New York Times the other day. It was by Kate Shaw and John Bash, titled "We Clerked for Justices Scalia and Stevens. America is Getting Heller Wrong." And they made the statement that there's this assumption that Heller just made the individual right to bear arms absolute, and they contend that the government has all kinds of leeway to restrict the kinds of firearms that can be purchased, or how they are to be used. And they said most of the obstacles to gun regulations are political and policy based, not legal. Well, based on what you've been saying, I think that's kind of an overstatement. Do you have a comment on that?
I agree with much of what you described them as saying, and I also agree that it's an overstatement. You have to decide, first of all, whether we're talking about home or outside the home. And then we have to talk about whether we're talking about self-defense or other things. Like in Iowa now, is it AR-15s you can use to hunt deer or something? Okay, that's a confrontation, I suppose, that you're having with the deer, but it's not anything like Dick Heller trying to protect himself in the house. And so those are factual issues that matter. They're right in saying that, Heller certainly did not say that you have something like an absolute right to possess a weapon. That passage, it's an unelaborated passage where they don't give a rationale, where they list those 4 or 5 things where they say, look, the Second Amendment's not a problem for regulations on the commercial sale of arms. It's not a problem for, keeping it out of the hands of the mentally ill. What does mentally ill mean? You suffer from depression. Does that mean you've lost your Second Amendment right to have a weapon? So what kinds of mental illness? What a murky world that is. And the court just kind of waves at it or points to it and says, well, mental illness may be a basis. If you're going to keep guns out of people's hands due to mental illness, you're going to have to give the legislature some latitude to write laws that will apply broadly enough to achieve the ends of keeping them from harming themselves and harming others. The more latitude you give a legislature, though, the more weight is placed on what the test is going to be. Because if it's strict scrutiny, they're going to say, boy, you better really have nailed this, really hammered down the kinds of felonies that you commit that lead to losing your Second Amendment rights, the kinds of mental illnesses that you have that lead to losing your Second Amendment rights. You better really very precisely define that. And that's going to be virtually impossible for a legislature. And so I would, it's more than just political will. If we're going to end up applying something like strict scrutiny, that does make it very hard to regulate, to write laws that are tailored enough. Although, as you say, and as they say at the same time, the Heller opinion itself says that a lot of these regulations are okay. Don't worry about it. Government will still have a lot of regulatory power. And so there's real tension. There's a lot of tension in the law that a lot of pressure, a lot of squeezing of the balloon. Something has to give. Either we're going to say, you know what, strict scrutiny applies in lots of these situations. And so the government's ability to regulate is not as wide ranging as the Heller opinion in dicta, meaning it didn't really matter, might have suggested. Or we might say, no, we have to give legislatures quite a bit of room. And the way we express that as courts, saying that you have quite a bit of room as a legislature to tackle the problems in your jurisdictions, you do that by ratcheting down the test. You say, well, we're not going to apply strict scrutiny because we're going to be invalidating almost all these laws. We have to do something closer to intermediate scrutiny. All those balancing things are really difficult for, I think, a judge to sort through.
I had a question. I was wondering, in the states, Missouri and Louisiana, that have adopted the definition of strict scrutiny, have there been any cases?
No, not yet. Now, I haven't looked in the last 12 months. I wrote a little article about Iowa's proposal for strict scrutiny amendments and did quite a bit of research about it. So I know about the area, but I've since written about some free speech things. I haven't gone back to update the research, but no, I don't think that there's been much. Because, what you need, a state that adopts a strict scrutiny amendment is not likely also to be churning out legislation that's highly restrictive of gun rights. You might have, what you need is perhaps a liberal city, a blue city in a red state, where that blue city under the state constitution has enough home rule power to be able to make its own calls about this kind of thing. And they adopt some kind of a strict gun regulation. So the stars that you need to align are not going to line up in a hurry. If a state's politics give you a strict scrutiny amendment, then the state legislature probably is being pretty permissive, going the way of the Iowa legislature, loosening things rather than tightening things.
Thanks.
Any other comments or questions?
I don't know anything about guns. This is Dorothy.
Hi, Dorothy.
And I know AR-15s are horrible, but I don't really understand how they function and why you would need it to go hunting. So if you could just give me a little
My comment on that.
Joseph, you might have something to say about this, just based on the expertise I kind of was sensing from you. I'm not a hunter myself. I've not shot an AR-15, but.
Well, I mentioned in my typed comment that if I were hunting deer, I would not use a .22 rifle because that would be inefficient.
You would not use an AR-15 or you would not use a .22?
An AR-15 is a brand name. And an AR-15 is a type of .22 rifle.
Okay.
And I would not use a .22 rifle on to hunt deer because, for one thing, it's inefficient. It probably would not kill the deer quickly, and it would be dangerous because the muzzle velocity of a gun like that is such that it could travel a great distance and possibly kill or injure some person or damage property or something. Because when you're shooting a gun, you always have to think beyond the target. You have to think of what lies beyond what you're shooting at.
Why do you say it would not kill the deer quickly?
It's a small caliber bullet. And a deer is a big
by
animal.
an AR-15.
If you shoot a deer with a .22 rifle, you could kill it instantly, but it would not be likely. You would have to shoot with extreme accuracy to do that. So
it was an AR-15 used in Texas, right?
Yes, I believe it was an AR-15, and the fellow who shot it was at very close proximity to the people he killed. So it would have been relatively easy for him to deliver a lethal bullet to each one of those targets. Also, I'm not familiar with whether or not these children died instantly. So those are two entirely different circumstances. Also, I can't help noticing a contradiction between somebody saying, I don't know anything about guns, and then saying, I know AR-15s are horrible. If you know nothing about guns, how do you know AR-15s are horrible?
Well, I mean, one possible answer, Dorothy, I'm sure can speak for herself, but speaking for myself, you know, the fact that they have to take DNA tests from family members in order to make, and this is a horrible thing to be talking about, but it's the reality that we're facing, in order to be able to make identifications. There's been a lot of press reporting about the kind of damage that is inflicted on a body by that weapon.
Certainly, if I shot you at point blank range with a 22 rifle, yeah, it would be an awful sight. It really would be.
Yeah.
That helped me. Thank you.
No, thank you.
As a cat.
Yeah, that's Vasco. He's my Portuguese cat.
Well,